Hello friends, welcome to the class of Legal Aspects of Business, where we will be studying the Negotiable Instrument Act 1881. Now, we all know and you might have studied the transactions which are required to be done in business. Business transactions happen through different modes or different instruments. Some of such instruments are negotiable instruments. These are certain set of instruments which comes under the Act of Negotiable Instrument Act 1881. There are certain documents which are freely used in commercial transactions and monetary dealings. These documents, if satisfy certain conditions, are known as a negotiable instruments. The word negotiable means transferable from one person to another in return for considerations, while instrument means a written document by which right is created in favor of some person. The law relating to negotiable instrument is contained in Negotiable Instrument Act 1881. The Act came into the force on 1st day of March 1882. According to the sections 13A of the Act, negotiable instrument means a promissory notes, bill of exchange or check payable either to order or to bearer, whether the word order or bearer appear on the instrument or not. In the words of Justice Wills, a negotiable instrument is one, the property in which is acquired by anyone who takes its bona fide and for value, notwithstanding any defects of the title in the person from whom he took it. A negotiable instrument may be defined as an instrument, the property in which is acquired by anyone who takes its bona fide and for value, notwithstanding any defect of title in the person from whom he took it. From which it follows that an instrument cannot be negotiable unless it is such and in such a state that the true owner could transfer the contract or engagement contained therein by simple delivery of instrument. Wills, The Law of Negotiable Securities, page number 6. According to these definitions, the following are the conditions of the negotiability. First, the instrument should be freely transferable. An instrument cannot be negotiable unless it is such and in such state that the true owner could transfer by simple delivery or endorsement and delivery. Second, the person who takes it for value and in good faith is not affected by the defect in the title of the transferor. Third, such a person can sue upon the instrument in his own name. Negotiability involves two elements, namely transferability free from equities and transferability by delivery or endorsement. Mukherjee J. in Taylor's Priya versus Gulab Chand AIR 1965 CAL. But the Act recognizes only three types of instrument versus promissory note, a bill of exchange and a check as a negotiable instrument. However, it does not mean that the other instruments are not negotiable. The instrument provided that they satisfied the following conditions of negotiability. Number first, the instrument should be freely transferable by the custom of trade. Transferability may be by number 1 delivery or number 2 endorsement and delivery. Number 2, the person who obtains it in good faith and for considerations gets it free from all the defects and can sue upon it in his own name. Third, the holder has the right to transfer. The negotiability continues till the maturity. Now, as we know that most of the important characteristics of negotiable instrument is negotiability, which makes them being a part of this act. One of the essential characteristics of a negotiable instrument is that it is freely transferable from one person to another. This transfer takes place either by one negotiations or two assignments. Now, we will turn on negotiations. Negotiations may be defined as the process by which a third party is constituted the holder of the instrument. This is to entitle him to the possessions of the same and to receive the amount due thereon in his own name. According to sections 14 of the Act, When a promissory note, bill of exchange or check is transferred to any person so as to constitute that person the holder thereof, the instrument is said to be negotiated. The main purpose and essence of the negotiations is to make the transferee of a promissory note, a bill of exchange or a check the holder thereof. Negotiations thus require two conditions to be fulfilled, namely, first, there must be a transfer of the instrument to another person, and the second one, the transfer must be made in such a manner as to constitute the transferee the holder of the instrument. Handing over a negotiable instrument to a servant for safe custody is not a negotiation. There must be a transfer with an intentions to pass title. There are basically two modes of transfer of negotiations, namely, first, negotiations by delivery, sections 47, where a promissory note or a bill of exchange or a check is payable to a bearer. It may be negotiated by delivery thereof. Example: A. The holder of a negotiable instrument payable to bearer delivers it to a B's agent to keep it for B. The instrument has been negotiated. Second, negotiations by endorsement and delivery, sections 48. A promissory note, a check or a bill exchange payable to order can be negotiated only by endorsement and delivery, unless the holder signs the endorsements on the instrument and delivers it. The transferee does not become a holder. If there are more pays than one, all must endorse it. Now we will move on assignment. In this, when a person transfers his right to receive the payment of a debt, assignment of the debt take place. Thus, where the holder of an instrument transfer it to another so as to confer a right on the transferee to receive the payment, transfer by assignments take place. Effect of negotiability. The general principle of law relating to transfer of property is that no one can pass a better title than he himself has a nemodet quod non habt. The exceptions of his general rule arise by virtue of a statute or by a custom. A negotiable instrument is one of the such exceptions which is originally a creation of mercantile custom. Thus, a bona fide transferee of a negotiable instrument for considerations without notice of any defect of title acquires the instrument free on any defect, that is, he acquires a better title than that of the transferor. Important characteristics of the negotiable instruments. Following are the important characteristics of negotiable instrument. First, the holder of the instrument is presumed to be the owner of the property contained in it. Second, they are freely transferable. Third, a holder in a due course gets the instrument free from all defects of a title of any previous holder. Fourth, the holder in a due course is entitled to sue on the instrument in his own name. Fifth, the instrument is transferable till maturity and in case of checks till it becomes stale on the expiry of 6 months from the date of issue. Number 6. Certain equal presumptions are applicable to all negotiable instruments unless the contrary is proved. Classifications of negotiable instruments. The negotiable instruments may be classified as under. First, bearer instruments. A promissory note, bill of exchange or check is payable to bearer when it is expressed to be so payable, or the only or last endorsement on the instrument is an endorsement in a blank. A person who is a holder of a bearer instrument can obtain the payment of the instrument. Second, order instruments. A promissory note, bill of exchange or check is a payable to order which is expressed to be so payable or which is expressed to be payable to a particular person and does not contain any words prohibiting transfer or indicating and intentions that it shall not be a transferable. Inland instruments, sections 11. A promissory note, bill of exchange or check drawn or made in India and made payable or drawn upon any person resident in India shall be deemed to be an inland instrument. Since a promissory note is not drawn on any person, an inland promissory note is one which is made payable in India. Subject to these exceptions, an inland instrument is one which is either first, drawn and made payable in India, or second, drawn in India upon some person's residence therein, even though it is made payable in a foreign country. 4. Foreign instruments. An instrument which is not an inland instrument is deemed to be a foreign instrument. The essentials of a foreign instrument includes that first, it must be drawn outside India and made payable outside or inside India, or second, it must be drawn in India and made payable outside India and drawn on a person resident outside India. Fifth, demand instruments, sections 19. A promissory note or a bill of exchange in which no time for payment is specified is an instrument payable on demand. Sixth, time instruments. Time instruments are those which are payable at some times in the future. Therefore, a promissory note or a bill of exchange payable after a fixed period or after sight or on a specific day or on the happening of an event which is certain to happen is known as a time instrument. The expressions after slight in a promissory note means that the payment cannot be demanded on it unless it has been shown to the maker. In the case of bill of exchange, the expressions after sight means after acceptance or after nothing for non-acceptance or after protest for non-acceptance. Seventh, ambiguous instruments, section 17. An instrument which in form is such that it may either be treated by the holder as a bill or as a note is an ambiguous instrument. Sections 5(2) of the English Bills of Exchange Act provides that where in a bill the drawer and the drawee are the same person, or where the drawee is a fictitious person or a person incompetent to contract, the holder may treat the instrument at his options either as a bill of exchange or as a promissory note. Bill drawn to or to the holder of the drawee or by an agent on his principal, or by one branch of a bank on another, or by the directions of a company or their cashiers are also ambiguous instrument. A promissory note addressed to a third person may be treated as a bill by such person by accepting it, while a bill not addressed to anyone may be treated as a note. But where the drawer and payee are the same, where I draw a bill payable to A's order, it is not an ambiguous instrument and cannot be treated as a promissory note. Once an instrument has been treated either as a bill or as a note, it cannot be treated differently afterwards. 8. Inchoate or incomplete instruments, sections 20. When one person signs and delivers to another a paper stamped in accordance with the law relating to negotiable instrument and either wholly blank or having written thereon an incomplete negotiable instrument, he thereby gives a prima facie authority to the holder thereof to make or complete, as the case may be, upon its negotiable instrument for any amount specified therein, and not exceeding the amount covered by the stamp. Such an instrument is called an inchoate instrument. The person so signing shall be liable upon such instrument in the capacity in which he signs the same to any holder in due course for such amount, provided that no person other than a holder in due course shall recover from the person delivering the instrument anything in excess of the amount intended by him to be paid thereon. The authority to fill up a blank or incomplete instrument may be exercised by any holder and not only the first holder to whom the instrument was delivered. The person signing and delivering the paper is liable both to a holder and a holder in a due course, but there is a difference in their respective rights. A holder can recover only when the person signing and delivering the paper agreed to pay under the instrument, while a holder in a due course can recover the whole amount made payable by the instrument provided that it is covered by the stamp, even though the amount authorized was smaller. The important parties which hold this negotiable instruments are explained in next point, which is known as a holder and holder in a due course. First we will discuss on holder. The holder of the promissory note, bill of exchange or cheque means any person entitled in his own name, first to the possessions thereof, and second to receive or recover the amount thereon from the parties thereto. If the note or bill or cheque is lost or destroyed, its holder is the person so entitled at the time of such loss or destructions. In order to be allowed to keep the instrument in his own name, the holder must be named therein as the payee or the endorsee in case the instrument is payable to order, or he must be the bearer if the instrument is payable or bearer. Now, holder in a due course. The definition of holder in a due course in sections 9 means that any person who for the considerations paid becomes the possessor of a negotiable instrument before its maturity, in good faith and without any sufficient reason to believe that any defect existed in the title of the person from whom he obtained it. A. He must be a holder in a due course. According to the law, due course means no citizens may be denied his or her legal rights, and all laws must conform to fundamental, accepted legal principles. He must be a holder eventually. B. He must be a holder of valuable considerations. Valuable considerations is a necessary element of a contract which tells about a benefit the other party. Valuable considerations can include money, work, performance, assets, a promise, or abstaining from an act. C. He must become a holder of the negotiable instrument before the date of maturity. D. He must be of good faith. Good faith means someone who has honest intent to act without taking an unfair advantage over another person, or to fulfill a promise to act, even when some legal technicality is not fulfilled. The term is applied to all kinds of transactions. Now that we have understood the meaning of negotiable instrument, let us understand the instruments included in Negotiable Instrument Act. Main negotiable instruments which are to be studied are promissory note, bill of exchange and cheques. Let us first understand the promissory note. Promissory note. According to the sections 4 of the Act, a promissory note is an instrument in writing, note being a bank note or a currency note, containing an unconditional undertaking, signed by the maker to pay a certain sum of money only to, or to order of a certain person or to the bearer of the instrument. The person who makes the promissory note and the promises to pay is called the maker. The person to whom the payment is to be made is called the payee. For example, Mr. A signed an instrument like, I promise to pay Mr. B or order rupees 500. This means the parties to promissory note are Mr. A, who is the maker, who promises to pay, and Mr. B is the payee to whom promise has been done by the maker. Parties to a promissory note. Let us now try to first understand the parties to a promissory note. A promissory note has the following parties. A. The maker, the person who makes or executes the note promising to pay the amount stated therein. B. The payee, one to whom the note is payable. C. The holder is either the payee or some other person to whom he may have endorsed the note. D. The endorser. E. The endorsee. Now let's understand the essentials or characteristics of promissory note. Essential characteristics, requirements of promissory notes. As you know, each instrument which is being a part of Negotiable Instrument Act contains certain features which make them different from others and easy to understand. Below are features of promissory notes. First, it must be in writing. The instrument must be in writing. A mere verbal promise is not enough and isn't considered a promissory note. There is no prescribed language or method, print, typewrite, pencil or ink. It must be in such a form which cannot be altered easily. Second, promise to pay. It must contain an expressions to promise to pay. A mere acknowledgement is not enough. Like Mr. A writes, I promise to pay B, or ordered rupees 500, or I acknowledge myself to be in debt to be in rupees 1000 to be paid on demand for the value received in case. Third, definite and unconditional. The condition or promise to pay must be definite and unconditional. If it is a conditional or uncertain, then the instrument is not valid. 4. Signed by the maker. The note must be signed by the maker, otherwise it is incomplete. Even if it is made by maker himself with his name on the note, still his signature must be there. Fifth, certain parties. The instrument must point out the parties very certainly which are mentioned in the promissory note, where the maker and the payee are not identified with certainty from the instrument. Even if it contains an unconditional promise to pay is not a promissory note. Sixth, amount must be certain. The sum to be paid must be certain and must not be able of contingent additions or subtractions. Now in the last part, we will discuss summary of Negotiable Instrument Act. So today we have learnt about the Negotiable Instrument Act 1881, which includes certain instruments which are negotiable, which means they can be transferred from one person to another. After that, we saw the characteristics of negotiable instruments, the various classifications of negotiable instruments and parties to the instruments. The instrument studied by us was promissory note. Promissory note is an instrument in writing which is unconditional and signed by the maker to pay a certain sum of money to a certain person. Hope this introductory lecture on Negotiable Instrument Act will help you in understanding the Act and the instruments included in it, which we learned today as well as in further sessions. Thank you.